So good morning, everyone. My name is Anna and I'm an Associate Solicitor at Ridouts. Welcome to the third in our series of Ridouts Autumn webinars. As you'll be able to see from the screen in front of you, this webinar relates to inquests. My colleague Caroline Barker, Solicitor and COO of Ridouts, is going to discuss what happens when inquests are held, the purpose of inquests, the process and the different conclusions that can be given at an inquest. My colleague Maddi Gaunt, solicitor at Ridouts, is then going to discuss practical tips for providers to assist with the inquest process, prevention of future death reports, and how to achieve a good outcome at an inquest. Before we do start, it's probably helpful if I go through a few housekeeping points. This webinar is going to be 45 minutes in length. And as the webinar progresses, you might think of questions that you want to ask either Caroline or Maddi. You'll be able to submit questions throughout this webinar by clicking on the Q&A button at the bottom of your screen. And I'll keep an eye on the questions as they come in, and then I'll direct the questions that you've asked to either Caroline or Maddi at the end of the session. We'll try to get through as many of the questions as we can as possible today, but if we aren't able to get through all of them, you'll be able to email us after the webinar. So that you know, this webinar will be recorded, so you'll be able to access it afterwards as well. We'll be sending a copy of the recording and the webinar slides to you following the event. We'll also upload the video onto our YouTube channel if you want to look at it there. And finally, please feel free to share the webinar with colleagues on social media as we go through the presentation or afterwards by circulating the link or slides. The hashtag for today, if you are going to post on social media, is Ridouts Webinars 2020. I'll now hand you over to my colleague, Caroline Barker.
Thanks, Anna. Thank you, everyone, for joining us this morning. So we often get phone calls from providers saying that a staff member has been asked to give evidence at an inquest, or they have been asked to provide service user notes to a coroner. And the first question we get asked is, should we be concerned? Should there be something that we ought to be doing? Now, my first slide gives you a flavour of why you might want to get involved with an inquest. Next slide. Now, these are actual headlines taken from the papers. Now, not every inquest is going to end up with a headline like this, but given the current issues that the sector is experiencing with low occupancy levels and the fact that requires improvement ratings are going to be harder to shift now that CQC are moving away from timetabled inspections, you certainly don't need a headline like this. And it's important to consider not only whether you ought to get involved in the first place, but also, having done so, what steps you should take. Next slide, please. It's important to understand when an inquest will be held. Now, an inquest won't be held in respect of every single death, but rather a coroner has a duty to investigate a death where they have reason to suspect that the deceased either died a violent death, an unnatural death, the cause of death is unknown, or the deceased died whilst in custody or state detention. So, for example, for our purposes, perhaps they were detained under the Mental Health Act. Now, with natural death versus unnatural deaths, the underlying medical cause of a death could actually be natural. So in the world of COVID is perfectly capable of being a natural cause of death, but it can become unnatural if there are additional factors such as human error or a failure in care that contributed to that death. So what would indicate to you as providers about why you should get involved with an inquest? Next slide, please. So, well, there might well have been a complaint by the family about the care that their loved one received whilst they were in your care, or perhaps they've decided to be legally represented at the inquest. Now, sometimes family members do want to be legally represented and appear at an inquest. there may be multiple interested persons, and that's a term that I'll discuss with you shortly. The police might have been involved. They may be investigating the death, or perhaps CQC are also investigating under their powers under the Health and Social Care Act. If the person was detained, that might be a flag. Or perhaps there were concerns around the care of the individual. Again, maybe there was a safeguarding with the local authority. Or perhaps staff members have been subject to disciplinary action as a result of issues surrounding the care of the individual in the lead up to the person's death. Next slide, please. Now, having said all that, the purpose of an inquest is actually to establish facts. It isn't supposed to apportion blame, and any conclusion reached should not use language that suggests civil or criminal liability. But the reality is, as you saw from the earlier headlines, that there are conclusions that can be reached and language used that may have a negative impact on the service. The inquest is there to actually answer 4 questions only: who the deceased was, when they died, and where they died. So 3 very normally straightforward and uncontroversial questions. But the 4th question, how the deceased came by their death, and this means by what means did they come to their death. Now, this last question can sometimes be widened if the inquest has to be subject to Article 2 of the Human Rights Act, and includes not only by what means, but also what were the circumstances of the death. So it's a broader question, and more detail will be provided within the recording of the conclusion. Now, given the limits of time today, I can't get into why an Article 2 would or wouldn't be held, but it's more to illustrate that meat will be put on the bones of a conclusion, and that's where some of the negative wording could come in, and that's what the press pick up in the headlines. Next slide, please. So how do you, as a provider, become involved in an inquest? Well, you can ask to become a properly interested person, and there are a number of people who are deemed to be properly interested persons within an inquest process. That will always be the family of the deceased, a medical practitioner that was involved in the care of the individual, and the location where the individual died, be it a care home or a hospital. Now, I've also seen CQC be granted interested person status, and also the police where they've been investigating the death. Although I have to say that I've never actually seen CQC attend an inquest where they've been granted that status. Now, the coroner's process is a little bit of a funny one. You have limited control, but by requesting and being granted interested person status, it gives you a greater amount of involvement and control than you would ordinarily have. Being an interested person allows you to have access to documentation that the coroner will seek to rely on at the inquest. Now, this includes the post-mortem, and this can prove invaluable. So, for example, I was involved in a case where a service user had taken their own life, and certain checks had to be undertaken on this individual and hadn't been taken at the time that they ought to have been. Now, we were obviously concerned about that in terms of what conclusions could be drawn and what negative findings might be made about that. However, gaining the post-mortem, we actually discovered that the manner in which the person took their own life meant that there were literally seconds in which that person could have been saved. So even if the checks had been carried out when they ought to have been done, it wouldn't have made a material difference to the fact that the person ended up taking their own life. So it can prove very useful to have access to these documents. As an interested person, you can also see witness statements that the coroner is seeking to rely on. And this allows you to consider whether there are any points that you need to address and provide your own statements so that you can help the process and help the coroner establish the facts. Now, whether you're an interested person or not, the coroner may well ask you to disclose certain documentation, and you have a duty to do so. You can't withhold any documents that paint you in an unfavourable light. Now, if there are some documents that perhaps aren't particularly great, then what is important is that we have a plan on how we deal with those documents. As an interested person, you're also allowed to ask questions of the witnesses at an inquest, which you wouldn't be able to do if you weren't an interested person. Now, as mentioned, family members and the police and CQC have all been granted interested person in inquests that we've been involved in, which means that they can also ask questions of witnesses too. Now, Maddi's going to talk to you a little bit more about police involvement and CQC involvement, but it's quite interesting that they are there as regulatory bodies, perhaps trying to gather further information for their own purposes. Now, in terms of witnesses, witnesses are ultimately decided by the coroner. They decide who they want to hear from, but as an interested person, you can suggest who else they might want to hear from. So you might think that a staff member has something particularly interesting to say or particularly helpful, and therefore you can put that forward to the coroner for consideration. Next slide, please. In terms of the process that is normally followed, you might actually be asked to attend what is known as a pre-inquest review hearing, also referred to as a PIR. And these take place when an inquest is particularly complex, in order to decide the scope of the inquest, decide who the witnesses ought to be, whether there should be a jury, because in some inquests, juries make the decisions, not just the coroner, and how long the inquest will actually be listed for. Now, a PIR might also take place where there are criminal investigations ongoing, and the PIR is there so that the coroner is kept up to date with the police investigations. A police investigation takes precedent over the inquest, so until the police indicate that they are not going to prosecute, an inquest won't take place. Now, on the day of the actual inquest, the inquest will be reopened, witnesses will give evidence, and the coroner will be the first person to ask questions of the witnesses. And as mentioned, other interested people, including the family, will be able to ask questions of the witness. So it's really important to be prepared for that. It is important to remember that inquests are a fact-finding exercise. They're not supposed to be adversarial. There aren't opening or closing speeches, and there should be no cross-examining of witnesses. But the reality is that questions can be posed to cast doubt on certain evidence, or perhaps be asked in a way to draw out particularly helpful points. And as a legally represented person, if there are concerns about the legal process that's being followed, then you can raise concerns throughout the process, which if you weren't legally represented, you wouldn't be able to do so. Next slide, please. So after all the evidence has been heard, then a conclusion will be delivered by the coroner or the jury if there is one. There are a number of short form conclusions that can be made, such as natural causes, accident, unlawful killing. However, a narrative conclusion may also be offered, which is a short description of the circumstances of the death, if the coroner or the jury doesn't think that the short form adequately captures the central issues in the case. So whilst no civil or criminal liability can be suggested, you can see from the example narrative conclusions that I've got on the slide, they do contain negative wording. So, for example, A died from an accidental overdose of his medication. He had not been provided with full instruction on how to take his medication. So therefore, there's a suggestion that he ought to have been told. By whom? When? Or B died as a result of jumping from the roof of the hospital. She had been clearly distressed in the lead up to her death. Her carers had not adequately assessed her condition and were not providing the constant supervision she obviously required, suggesting a failure in care. And these are the types of things that are picked up in the press headlines that I highlighted at the beginning of the webinar. Next slide. Now, the other additional conclusion that can be of concern to providers is that of neglect. Now, neglect, actually, I'm going to contradict myself there, isn't a conclusion in its own right, but the coroner can decide to make a finding of contributory neglect, either as part of a short form conclusion or as a narrative. Now, the meaning of neglect in coronial terms is actually very limited. It is a gross failure to provide basic care to a person who is in a dependent position, so it could be due to age, illness, or the fact that they're detained, and that the deceased's condition was known or should have been known to be such that action was required. However, the failure has to have a clear and direct causal connection to the death. Next slide, please. Now, a finding of neglect or negative findings can have far-reaching implications for a provider. It can attract media interest. Now, inquests are held in public. They have to be held in public, and therefore quite often they attract the media and the press. So you might find that the press pick these up following any conclusion. It may also prompt CQC to come back into your home, or perhaps your other homes. They might look at a provider level if they've got concerns about particular issues in the case. Negative conclusions might also give weight to a civil claim, and particularly where the family is involved with the inquest, it might determine that they are looking to make a civil claim against you as a provider. Or it might even lead to police investigations being reopened if something came to light in the inquest, which means they want to have another look at the care. In addition, following the inquest, a coroner is under a duty to issue what is known as a Regulation 28 report, also known as a Prevention of Future Deaths report. Now, Maddi is going to talk again in more detail to you about this. But what is important is that you can actually potentially avoid a Regulation 28 report by becoming involved in the inquest early on and planning out how you approach it. So there are some reasons why you might want to get involved with an inquest, and hopefully gives you a better understanding about what inquests are all about. I'm going to hand over to Maddi now, who's going to speak to you about some of the more practical elements of getting involved with the inquest.
Thanks, Caroline, and thank you, Anna, and thank you all for joining. Hopefully that's been a useful overview of some of the process and procedure. This presentation is just to give you a few practical tips, which I hope you can draw on if providers do find themselves involved in an inquest. Can I have the first slide, please? So, as Caroline has explained, the coroner can issue a report to certain individuals, organisations or bodies to request action be taken to prevent future deaths, or a PFD, or also you'll hear them referred to as a Reg 28 report. The powers come from the paragraph 7, schedule 5 of the Coroners and Justice Act and regulation 28 of the Coroners Investigation Regulations 2013. These reports set out the coroner's areas of concern, and these are usually born out of the evidence heard at the inquest, but they can go beyond that. So, for example, if there's something buried in a document somewhere, it could still be picked up. And concerns can often be something which might in other contexts seem quite minor. As Caroline said, it's not a choice. If a coroner believes there is something which can be done by a party, they do have a duty to issue the report to them. And the PFD can be addressed to more than one party. For example, it could be addressed to a care home because of concerns over care, and to the CQC for failing to monitor that home properly. Addressees must respond within 56 days, subject to extensions at the coroner's discretion, and the response must explain what will be or has been done to address the concerns, or if nothing's going to be done, explain why. And PFDs, can be copied to a wide range of parties. That includes some which aren't directly involved in the inquest, and the coroner also publishes them and sometimes any responses, so they are easily accessible to the public and regularly picked up by the press. Next slide, please. So Caroline's already covered in general terms what the impact of negative outcomes can be, but for a PFD, you are going to have to do something. Depending on what the concerns are, it could cost a lot of time and money to put whatever that is right. And if nothing else, you are going to have the effort of preparing a robust response to satisfy the coroner. Your reputation might also take a hit, particularly if the concerns are serious or not yet remedied. You might find yourself in hot water with commissioning bodies who could, for example, use PFDs to increase scrutiny of your service, or in extreme cases as the basis for imposing embargoes or possibly even terminating agreements. It might become more difficult to attract new service users or possibly good quality staff or even investment if that's something you're looking into. And you may find that this does also feed into relationships with existing service users. They may get distressed, families may start refusing to pay bills, advocates might start to make demands about quality assurance. You know, in extreme cases, people might look to move. Now, while an inquest doesn't officially apportion blame, a PFD may well form the basis of civil claims for damages, for example, and in some cases, as Caroline said, could also prompt further criminal investigation or a past investigation to be reopened. You may also find that the CQC come knocking. Remember, they're currently taking an intelligence-led approach to activity, and inquests and PFDs are likely to be a pretty obvious source of intelligence for them to pick up concerns which they'll then act on. Other regulars might also get involved, such as the HSE, for example, if it's a death of a staff member. Essentially, you want to avoid a PFD if you can at all. Next slide, please. So we know a PFD is a bad outcome. Question is, what does a good outcome look like for providers? Well, it really will depend on the circumstances and your level of involvement. In exceptional circumstances, well-presented evidence given early can sometimes satisfy the coroner that an inquest doesn't even need to be held at all. So, for example, show that it is definitely natural causes. So that's a possibility. You really do want to avoid a PFD if you can help it, as we've seen. Even if you don't get a PFD, you still want to avoid public criticism as far as possible. For most clients, a short and streamlined inquest on narrow points with few witnesses is normally favourable, and that's going to cost you the least in time and effort. You do want to avoid bad press if you can, and if there is negative coverage, a good outcome could be to ensure that you get your own position across, for example. And finally, it's not always about damage limitation. You can reach positive outcomes at an inquest. The coroner might, for example, note in a conclusion that the care received was very good. And while this won't really determine anything, it could help you later defend any claims or deal with negative press, for example. Next slide, please. So what can providers do to help themselves reach a good outcome? Well, again, each inquest will be different, but there are a few things you can think about in the build-up to help put yourself in the strongest possible position. The earlier you get legal advice, the more options you're likely to have and the better prepared you're likely to be. Early advice and engagement is likely to give you the best chance of having any control over the proceedings. Even if you can't get advice, do engage with the process. Ultimately, if the coroner wants you there as a witness, you'll have to attend. But whether you have to be involved or not, your position is normally going to be better if you do, and you engage positively and participate as an interested person. Prepare, ensure you know what to expect, what the outcomes might be, have an idea of who else might attend, do read their evidence, particularly from all the other witnesses who are giving oral evidence. Try and anticipate criticisms you're going to face, and do consider what your responses will be in advance. Ensure you've put in the evidence that you think is relevant to what the coroner's asked, and consider what else you might want to say if other things do crop up. If your staff are giving evidence, ensure that they're prepared as well. If at all possible, ensure they've got access to legal advice. And in some cases, this should be fully independent from a provider's own. Also, think more broadly about logistics leading up to the day. Do you need to set time aside? Do you need to get staff cover in so you can prepare? Do you need to have someone on hand at the service to send you documents on the day? Do you need to have press releases available for different outcomes? On the note of preparation again, legal representation will usually give you more rights, and good representation can make a difference. And we are finding there's a bit of a diary bottleneck at the moment for good barristers. So if you're going to instruct an advocate, do try and instruct them early on. This last bullet is probably the most important thing you can do and is critical in the build up to an inquest. If there are any shortfalls that have been identified, whether by you in an internal investigation or in any of the evidence given to the coroner, come prepared to explain what's been done to fix it. You are going to want to try and show the coroner that nothing more could be done by you, at least now, if not before, to avoid a PFD, for example. Next slide, please. So as you get to the inquest itself, there are a few other things that you can do to help improve prospects. Be helpful and respectful to the coroner, be polite. It's a formal process, and if you are called as a witness, you're going to be given evidence under oath. It's okay to be nervous, but do try and stick to the point, stay calm, think through your answers, and avoid being overly defensive. And being nice to the coroner's staff usually will go in your favour too. Know what to expect. Well, hopefully today's session will have given you at least some help on that. But the more you know, the less likely you're going to be caught by surprise on the day, and the better you're going to come across. Remember to reread your own evidence and relevant documents and have copies with you. The inquest could be months or even years after it was prepared, so do make sure you know what's in it. Support your staff. Often employees will be the ones actually giving the evidence, and you'll want them to present the service in the best light. Ensure that they are properly prepared and supported throughout as well. And finally, be respectful to the other parties, but do stick up for yourselves. Emotions might run high, the family might be there, you might have ex-staff members gunning for a fight, commissioning bodies could be sniffing around, the CQC, the police, members of the public, it goes on. And how you come across to all those others and to the coroner will make a difference to the credibility of your evidence and how you're seen by the other parties and possibly the press if they're there. Do, however, remember that other parties may have interests which conflicts with yours, and if their evidence or questioning, or indeed the coroner's questions, do start straying into territory which makes you feel that you're more likely to be subject to criticism, you might want to be prepared to deal with it appropriately, of course, and ensure that the coroner and the public hears your side of the story. Next slide, please. So you've done all you can, but what if you can't get the result you were hoping for? What can you do about it? Well, this probably goes without saying, but don't ignore it. If you haven't already, you should fix what needs to be fixed and do ensure that that's documented and monitored going forward. If there's a PFD, respond to it in the timescales and do what you say you will. If there are other criticisms, deal with them as necessary. Decide on an approach to press and PR, both internally and externally, and for the positive and negative messages, but do be prepared to act quickly and handle them carefully. Now, there's no right or wrong approach to this, but do consider that there's going to be a range of personalities involved. You know, we've got grieving families, we've got service users, we've got commissioners, etc. So any approach you take will just need to bear in mind that the scope of the audience is pretty wide, and you don't want to antagonise people or make matters worse. Do prepare for regulatory scrutiny, assume it's going to come after a PFD, whether by enforcement or inspection activity. This is really a good time, if you haven't already, to take stock, check and ensure compliance with all your regulatory requirements. This is not limited to the subject matter of the inquest. The CQC could, for example, come knocking, looking for safeguarding issues, but actually find PPE compliance to be a nightmare. What you don't want to do is give them easy pickings. Do prepare for threats of claims. There are some red flags which will probably give you a good idea if it's likely, so family complaints, for example, but criticism at an inquest will probably increase the likelihood of them coming. If you do receive a claim or a threat of a claim, don't assume it has merit, but also don't assume it hasn't or ignore it. Get legal advice early if you can. Either way, don't waste time, because there are some stages in claim procedures which have quite strict time limits that you will want to meet. There might even be an increase in claims in the wake of COVID more generally. So as a precautionary measure and to help preserve any cover you've got, it might be worth reading over what insurance cover you have in place for claims now, and just knowing what to do if one does come your way in future. Learn lessons. Again, sorry to keep banging on about this, but as we've said, if the process uncovers any shortfalls in your service, whether they're big or small, whether or not the coroner picks up on them even, deal with them if you can. Identify what needs to be done, take and document actions that are taken, monitor them, and do ensure, for example, that that information is also cascaded down to staff and throughout the organisation as necessary. Really don't want to be involved in another inquest or a dispute with the same concerns arising if you can help it, because your position is going to be a lot weaker the next time round. At the same time, do be wary of acknowledging fault. There is a difference between admitting that there might have been shortfalls and there are lessons to be learned, and admitting that you have done something legally wrong. No, this does also apply before and during the inquest too, so just be careful when you are admitting things might not have gone right. Finally, you could also consider an appeal. There's a couple of options for challenging coroner's conclusions, but there isn't an automatic right of appeal, so you do have to apply for permission, and there can be little incentive to do so, because the outcome on a successful appeal is often to go through it all again. So it's difficult, but not impossible to appeal. But in some circumstances, and particularly where the coroner's conclusions are very damaging, it might be worth exploring. But if you're going to do that, do it quickly, because there are time limits that apply under one of the procedures. So that's it for my slides. I suppose by way of summing up my part, in most cases, the right response can really significantly limit the damage which a negative outcome at an inquest might otherwise cause. But if you can, you want to push to get a good outcome in the first place. I appreciate that was a lot of information, and I'm sure it's only scratched the surface, but I hope it's been helpful. Thank you for giving up your time. And I'm going to now turn back to Anna for some final thoughts before we turn to our Q&A session. Thank you.
Thank you, Caroline and Maddi, for that. That was a really clear explanation of the inquest process, and you also offered some helpful and practical tips as well. In terms of key takeaways from your presentations, you've explained that the purpose of an inquest is to establish fact and not to apportion blame. There are benefits to becoming involved in the inquest process at an early stage, for example, requesting interested person status. Adverse findings can have a negative impact on your business, but there are ways to help achieve a good outcome. And also, if there is a negative outcome, you can also take steps to address this. So there's definitely some helpful things to take away there. Whilst you've been doing your presentations, we've had a variety of different questions come in. So I'm going to direct them to Maddi and Caroline now. Caroline, if we start with you, one of the questions that has come in is CQC is now leaving cases open until an inquest has been heard. Can you explain what some of the risks are with this?
Sure, yeah, thanks very much. Well, yes, CQC, interesting, as I say, that we've seen inquests where CQC have actually been interested persons in an inquest, and quite often we feel that this is a way for them to gather further information through the inquest channels. I think it's important to remember, though, that CQC have processes which are entirely different and separate to an inquest. CQC have to determine whether there have been failings under the relevant regulations, and whilst the inquest might help them gather some lines of inquiry, they ought to be carrying out their own inquiries themselves. Evidence presented in an inquest and the conclusions drawn are not evidence of a failure, regulatory failure, that CQC could then take action against. But you're quite right to be concerned. CQC could well be using the inquest process to gather evidence or to gather lines of inquiry, and potentially outside of their regulatory framework. So ordinarily CQC would have to come in and inspect or request certain documentation under Section 64 or Section 65 of the Health and Social Care Act. So it's quite a clever way for them to get additional information. So definitely something to be aware of, but they would have to demonstrate any failures in meeting the regulations under their own framework.
Thank you, Caroline. And Maddi, a question for you. Is the outcome of an inquest made public?
Well, as Caroline explained, the whole inquest process is open to the public, and save for exceptional circumstances, the public do have full access. I actually myself was sat in listening to one yesterday, but the report, if there is a PFD or a Reg 28 report, yes, they can be accessed. They're very easily available. They're on the judiciary.gov website. And it's not difficult to find them. And as I also explained, in some cases, they will also publish a response to the Regulation 28 report. So people can also see what you have done about the problems as well. So actually that response publication can be quite important if the Reg 28 report is particularly critical, because then you've got another mechanism to help you get what you have done over to the public as well.
Thank you, Maddi. And then Caroline, a question for you. In the event that a coroner issues a PFD, if a provider can show that they did all that they could to prevent a death, can they request that their details are redacted?
Interesting question. The purpose of a PFD report is where the coroner believes that there has actually been some failure. So the coroner is under a duty to issue a PFD report where they feel that future deaths could be prevented. So something occurred in this particular case which demonstrated that there was some contribution to the death. Now, PFD reports wouldn't necessarily criticise all parties involved, but of course the likelihood is that where somebody has died within your care, then you are going to be an obvious focal point. So part of the PFD report is to actually write a potential risk in the future. So it's unlikely that you could have your names redacted. You can make representations to the coroner, to the chief coroner about this, but most are, as Maddi said, published and made public because it's in the public interest to understand the issues involved. I think in terms of your best bet, as Maddi mentioned in her presentation, is to try and preempt some of the issues and some of the concerns so that a PFD report isn't actually issued in the first place. And we've had a number of successes when we've been representing providers at coroner's inquests, because there are issues that arise during reviewing of the paperwork. And we have put together then statements from senior people within the organisation to say exactly what they've done and what they will do in order to minimise those risks. And that demonstrates to the coroner that a prevention of future deaths report isn't actually required.
Thanks, Caroline. And I think this links to the first question and the answer you gave. So I'll just direct this to you as well. Where an inquest has been heard and no PFD has been issued, can CQC still prosecute based on system failure that they have identified?
Sure. Well, again, it is linked to what you're quite right. It is linked to the first question. CQC have to gather evidence. They have to gather their own evidence. They can't simply say, oh, there's a particular finding in the inquest, therefore that is evidence of a regulatory breach. They would have to demonstrate, with reference to documentation and evidence and taking statements, etc., from people, that there has been a failure. Now, that is, as I say, an entirely separate process to the inquest process. CQC have, they can prosecute for breaches of regulation, but you would have every right to put forward your case as part of that process. So I think it's important to remember the two processes are separate, and yes, one can inform the other, but it isn't evidence of a regulatory breach under the Health and Social Care Act. And I think that's what everyone has to remember, that the CQC has powers only under the Health and Social Care Act and not other frameworks.
Thanks, Caroline. And Maddi, just one final question. Somebody has come in with the question, I have an ex-member of staff who has been called as a witness, but relations between us have soured since they were called. What's the best way of handling this?
Thanks, Anna. Well, unfortunately, this is pretty common, partly because inquests are taking so long to come about at the moment, and quite often because during investigations you find that staff members have been a bit of a problem. You handle it delicately is the answer. From a legal advice perspective, your ex-employee should almost always be separately legally advised. Remember, you might have conflicting interests, and your ex-staff member might be tempted, particularly if it was contentious, to throw you under a bus. So what you want to do is try and maintain positive relations as far as possible. In some circumstances, if you're both legally represented, your advocates might be able to find a way to work together to minimise the risk of throwing each other under that bus. Read their evidence very carefully in advance. If there's an allegation that they might try and throw at you, just be prepared to deal with that. Do bear in mind if there's any ongoing disciplinary proceedings that you might need to tread particularly carefully, and ensure, for example, that HR are aware if that's going on. And you can, I suppose, also make suggestions throughout the process as to who is going to be a witness if you're an interested person. So if you have an ex-staff member and it's ended very badly, for example, and you think that they might be inclined to throw some dirt at you during the inquest, you may want to make a suggestion that somebody else from the organisation should also give evidence, so the coroner can hear a more or less biased version of what happened, perhaps. Thanks.
Thanks, Maddi. Thank you, Caroline and Maddi, for guiding us through the inquest process today. And thank you to everyone for joining. We know that it's a really difficult time for providers at the moment, so we're really grateful that you took the time out of your day to join us, and we hope that you've found it helpful. As I mentioned at the start, these slides will be circulated with you following the event, and you will be able to access the slides on our website as well. Next slide, please. As you will see from the slide here, we've got our final Providers' Choice webinar, which is taking place on the 10th of December. This webinar is based on feedback that providers have given us in relation to what topics they want to see covered. So we're going to be looking at the transitional monitoring approach, CQC's transitional monitoring approach, and what's happened so far. We'll also consider the Mental Capacity Act and what's happening with the liberty protection safeguards. And to wrap the webinar series up, we'll be considering lessons learnt from COVID-19 and the way forward. And to reserve a place on that webinar, you can do so by accessing www.ridouts-law.com. We also have a Twitter page and LinkedIn page if you need any information from us and want to reach out to us there. So to close, I'd like to say thank you very much for joining the webinar, everyone, and we hope to see you again very soon. Thank you.